take that anger that you initially get whenever you get the email or whatever, use that to motivate yourself to write a response, but do not send it at that time.
Oh, okay.
Give yourself a day or a couple hours, come back to it, because I have written some things, like whole emails, and I just, you know what, it's not even worth my time to send it, because it's just gonna cause me more headache when they respond.
Yeah.
So I'm just gonna delete that. Or, all right, I need to just tone that down, or sometimes I even punch it up, where it's like, okay, I could actually just phrase that better and it's actually stronger, but it's not as like biting. I never wanna be like, sometimes they're getting personal and they're making personal mistakes, and it's like, okay, I'm gonna point that out.
Yeah.
But most of the time you wanna just address the facts of the case.
Right.
Obviously that goes a little different when they're acting in bad faith. But it's, I hope that answers
Are you
the
of the
question.
opinion that you get more flies with honey?
100%.
Okay. So
100%.
That's your approach.
And it's partly I've learned it from you, and I am humble enough to say, like when I first started, it's like, okay, I'm learning from a person. He's a partner. He's at that point that I started, you were probably 28. I was like, I'm working for a 28-year-old. He's a partner at a law firm. I don't know how to do anything. I've never done this job before. Well, what can I do? I can just copy what he did because it's working. Clearly, like, how would you be a partner if it wasn't working? So it is. So just copy that. And you have that same mentality of you catch more flies with honey than you do vinegar.
Yeah.
And I'm just going to copy it. Now I'm going to change things a little bit, especially as I get a little bit more confident, and I've settled a lot of cases myself now, and I'm getting, good results. I can kind of say, okay, well, here's where I'll deviate, or I would explain this thing a little differently or whatever. But yeah, it's 100% true. And it's like with that, one of those cases, I get a call from a defense attorney, and it's like, oh, I've worked with Jess and I've worked with Stephanie before. You guys you're good attorneys. Well, what can we do to get this done? That's such a better conversation to have than a screaming match or whatever other, the types of conversations that we can have with defense counsel where they're just being unreasonable. I'd much rather have that collegial, just like, can we just talk and just get this done?
And I think that benefits the client too, because if we have a cordial relationship with opposing counsel,
that's the right word. Cordial.
They're not going to potentially make the experience for our clients a living hell, which we have had some opposing counsels, over subpoena client information or be really combative during depositions and really stress out a client or be particularly upsetting. So I do think that those relationships to some extent can benefit our clients. There are some that seep through that are, can be a little tricky, but we're with these same people all the time.
Yeah.
And, they have their same clients, and, we bring a different client, different set of facts to the table every time. So, but yeah, Mike had always said to me, like, each attorney will find their own voice as far as how they litigate cases, how they negotiate them. And that is very true, that every response is different. And I've gotten a lot out of seeing, Max's responses. He has, more experience even on me. And, a lot of his responses come from, again, trial and error and seeing what works and what doesn't. And, I think that the biggest thing that I've learned in my career is I have to constantly be open to feedback and other ideas. And I love when people come to me with ideas, and I don't look at, oh, this person's an associate, this person's younger than me. I look at it, what ideas they bring to the table. You come up with incredible ideas all the time.
Thanks.
That I think are really good and should be implemented. And if I was closed off, or if anyone's closed off to that, they're only shortchanging themselves.
Right, and I think that's part of why it's a losing proposition to be closed off. I mean, why would you want to do that? You shouldn't. Like, if an idea is good, it will make the firm, our clients, us personally, more money. So why would we not want to implement it? It doesn't matter where it came from. It doesn't matter if it came from the receptionist. It doesn't matter if it came from the guy who's delivering our we got new merch today.
Yeah.
If he just happened to say something that was incriable, let's take it.
Yeah.
Like, oh, you guys should change. I don't like that painting is different or whatever.
Right.
You should change that.
Yeah.
We have every incentive to adopt good ideas. And so, I think that a lot of that problem is, I think, more in defense firms.
Yes.
And there are definitely some plaintiffs firms that are like that.
Yeah.
But I think it is typically when they're older, like more just like set in their ways firms. Like the lawyers themselves don't have to be old, but it's just like an older firm where it's just like, this is the way that we've done things for the last 50 years. It's
Right.
like, no.
And then when you challenge it and say why, they say because we've always done it this way.
It's like,
And
okay,
then,
that doesn't mean anything.
yeah, and then it's not really going
I
anywhere.
don't care what worked in a personal injury case back in the 80s.
Mm-hmm.
we're in
Right.
the 2020s now. Like things are a lot different.
Oh, 100%. I mean, with the emergence, and Mike talks about this with AI and all these other technologies that we can be using. I think that we hear a lot of the negative things about AI, and we certainly have to be careful.
100%.
But there's a lot of benefits that are not being used that we're hearing about and that Mike's trying to incorporate into practice. And have you been utilizing any of those, or what have you seen?
100%. And I think it is part of the older generation, because when I told my old boss, who is close to 80 years old, I realized he's actually 50 years, almost exactly older than I am. So he's actually 77. But I always just think of him as being closer to 80. Like he is 80 in my head. But I told him, I was like, oh yeah, we use AI. AI helps us write demand letters. AI helps us do this. I use ChatGPT a lot. He's like, oh, you got to be really careful with that stuff. Because all they hear is lawyers getting reprimanded for using it in a dumb way, which is where they're using it to write motions and it's making up fake cases.
Yeah.
And it's like, well, no. I'm not using it for that. Because I know that that's dumb. I see the same thing. People are getting in trouble for that. But if I can take a deposition transcript and upload it to ChatGPT and have it summarized in 30 seconds, that is much better than me spending an hour going through it and writing down the key points. Like if I'm doing a mediation submission, and I did one on Goodlow, that trucking case, I used AI to summarize 4 dep transcripts. It probably took me 15, 20 minutes to get a good summary and to put that in a mediation submission, as opposed to, it would probably take 2 or 3 hours to do the same work. And I was able to do it in 15, 20 minutes. It benefits me, it benefits the client, it benefits everyone, because now I can help more people. And honestly, it's probably better because the AI doesn't get tired. It doesn't miss things, in theory. I might, I just read through that question, but that was actually important.
Right.
So I think a lot of that stuff is very helpful. Obviously, like you said, you got to be careful with what you use it on. But for the most part, if you don't use it on anything where it can hallucinate like a case, it's so helpful, especially with like thinking of different ways to argue things. Or like if I have a weird premises case, like I describe the situation in ChatGPT, give me 10 reasons why the landlord was negligent. And it'll come up with 3 that I hadn't even thought of. And maybe 3 of them, maybe 2 of the 3 are like they don't even make sense, or they're just bad, but one is like, oh, that's good. I'll put it in the complaint.
Yeah, it's just another way of thinking, for sure. Do you, they talk a lot about AI going after jobs and AI potentially making certain industries obsolete. Do you think that that's a risk for what we do?
I would say the bigger risk is if somehow AI helps. Obviously, you have Teslas and you have other vehicles that can kind of drive themselves. If those get to the point where there's not as many motor vehicle accidents, obviously I would like that to happen, because that means less people are getting hurt. But I would be a little sad that maybe my job is not going to be there.
Yeah.
But I think that's more of a threat to our line of work, but it would be a happy outcome. But as far as taking away our job, I don't think so. I don't think AI is not going to be walking in and trying a case anytime soon.
Yeah.
It's not going to be, I think, getting on the phone and arguing with an adjuster. It's helpful at where it's at. I don't think it's a pretty big leap to imagine it doing our whole job. What I really think it'll do is it might knock off some of the lawyers that, for lack of a better phrase, are at the bottom. Like they're not like obviously there's going to be some lawyers that they're just not as good as others. And there's the bottom 10% of plaintiffs' lawyers, 20%, 30%. They might not be able to compete, not be able to handle it. Whereas we might, right now, what do we have? 80, 90, 100 cases usually between each attorney. Well, we might be able to have 200 or 300 if we have AI that can help us, just compile facts or just do whatever. And that just, it serves everybody, because it helps the better lawyers help more people in a better way.
Right.
So it's actually a net positive. So I'm not really worried about it.
I think that how I anticipate seeing it, I might, in a sense, cause an influx of cases to us, because I think that AI will be more relied upon from a claims adjustment standpoint, because there is such a shortage for claims adjusters. And I think that they will rely on AI to spit out a number that is non-negotiable, and that will force more people to hire lawyers, or it'll force more lawsuits to have to be filed. I think I could very easily see it going that direction, because we are seeing it a lot more with these like pretty heavy hitting insurance companies, the big, ones that advertise all the time, where they spit out a number and it's not really negotiable. It's take it or leave it. And I do think they rely on software. I do think they look at jury verdicts and CPT codes and spit out with an average that, there may be some justification to, but the reality is they don't know what 12 people are going to do.
Right.
So I see that very easily with AI.
I think they're terrified of it too. Because I think if it's going to take anyone's job, it's going to take the defense attorney's job or the claims job. It's going to replace a lot of those jobs in a way.
Right.
And I know that. Well, one, they also rely on the billable hour, right?
Yeah.
So it's going to maybe change their pay structure because if you can, like I said, summarize a dep in 30 seconds as opposed to an hour, well, that just not your bill. If you're charging $500 an hour, you're not getting that $500 now. You're getting, $1 because it's in 30 seconds.
Yeah.
So there's that. But I also, I put in the team chat the other day that I told Lexitas that we don't want those AI, those deposition insights.
Yeah.
Because they charge like $50 a pop. It's ridiculous.
Right.
But the other attorney on the other side said, we're not even, if you send that to us, this is a defense attorney, if you send that to us, I can't even attach it to the file. That's how it is not allowed at all. And I guess that there is a court reporting service, I forget the name of it now, I think like Parrot Legal or something, that they don't even have like a court reporter there. It's like all AI. I don't even know how it's allowed. But he said that if a plaintiff's firm if they notice up a dep and they're using that court reporting service, we have to hire our own court reporting service because we're not allowed to use that because they're just like no AI at all.
Wow.
So that tells me that they're either
something going
very worried about like somehow that's going to like be ethically wrong or something, which I don't really see, or they're just terrified that if they start implementing it, it's going to very quickly reduce all their billables down.
That's a fair point. And I'm curious. I want to segue to this thing with AI, and because I just thought of it. So if you have a client or a potential client, for example, and they say, why would I hire you guys if I could have AI write my demand letter, or if I could have AI handle my correspondence with an adjuster? What would you say to them? What do you think is, sets us apart from AI? Because we do agree it is cool.
Yeah, no, I would say, well, why can't you do both? I mean, obviously the AI, it's going to charge, in theory, I guess, less because it only costs $20 a month to have a ChatGPT. But right now, that can't talk to an adjuster. That can't call an adjuster. That can't also see. Sometimes there's intricacies that are not there. Can you describe your pain and suffering to an AI, a large language model? Sure. But also, is it going to have a relationship with an adjuster? I just told you and Mike about a case that we had that another attorney had referred over to our case or over to our firm. The total offer for the 3 clients was about what their medical bills were, which was $14,000. And we refiled the case. A new defense attorney gets put onto the file. It's one that I just happened to work with before. He actually went to the same high school as Max, not at the same time, but he was a few years ahead of Max. And he was like, when I told Max about it, I was like, oh yeah, I'm dealing with this guy. He's like, I went to high school with him. Tell him I said hello. So I did. Because that's a human relationship. And what did he respond with? He's like, I always wondered where Max from Disparty went. Tell him I say hi from Mount Carmel. Yeah. And I was like, okay, cool. The end of that paragraph, or the end of that email was, okay, we can increase the offer to this. And I end up getting an extra $10,000 in the case because of the relationship. ChatGPT doesn't have that relationship.
Right.
So yeah, I can make all the arguments in the world. But a lot of times they don't really care about the argument. It's the threat of the person behind it. Yeah. So that's what I would say is that you can use ChatGPT all you want, but ChatGPT can't file a lawsuit for you. And that's really the threat. Yeah. Is that I can put some words down on a piece of paper, sign my name to it, and now you have a lawsuit. Yeah. ChatGPT can't do that. It doesn't have a law license.
Oh, for sure. And I think that the other facet is ChatGPT obviously is as effective as the data that you put into it. Yep. And what clients don't realize, especially if they are trying to handle the case on their own, is that you are potentially divulging information that is harmful to your case. And I can think of the cases that we've gotten where clients have tried to negotiate before we became involved, and they've always said some very boneheaded things that I've had to.
You should share one or two.
Well, so for example, I had a client that had talked about how she had put it in a demand letter that she consistently before this incident was lifting 220 pounds. Weekly or something kind of along those lines. And of course...
In her head, what is she thinking? She's thinking, well, I was in good shape. I was able to do this stuff.
Right.
But what does the defense see?
Yeah, they say, oh, well, you no wonder your back is hurting. No wonder you hurt your back lifting 220 pounds on a weekly basis.
And we know that because you just told us.
Yeah. Yeah.
It's not like we made it up. You just told us you were using your back all the time. You must have strained it from all that strenuous activity.
Oh, 100%. And then we'll have clients that'll oftentimes not be as forceful about something. We'll see that oftentimes with like a coverage case where it's a arguable question as far as the frequency that they're living on a property. We had a case where it was an adult child, and he would bounce between his mom and his dad's house. And those kinds of cases really can hinge on the frequency of what household you're in more so than another, which you don't know, as
Right.
as a non-attorney. And they were a little flippant in their correspondence as far as being a little wishy-washy. And that invited, an issue with coverage that we
Right.
had to, unwind. So I think that the reality is that we are constantly looking 10 to 15 steps ahead. And the clients that's potentially negotiating on their own behalf, they're looking in the present or not even, maybe one step ahead at best.
Yeah.
And so there's been quite a few cases where it's just been really troublesome. And they've tried to save money, but in actuality, they've probably lost themselves money because of some of the mistakes that they've made.
Which is a shame. I don't. Obviously, I like that we have a job, but it really sucks that we have to exist.
Yeah.
But it's for a reason. I mean, I always point out when you walk around out here in Chicago, there's always, especially in the winter, there are signs outside most buildings that say
Right.
"Caution, falling ice."
Yeah.
They didn't put that out there just because they like to be nice to people.
Right.
They put that out there because somebody sued them and they lost big time.
Yeah.
So now they put it out there. So we're making the world safer, and
Yeah.
that's good.
Absolutely.
Nobody wants to be injured. Nobody wants to get hit in the head with a block of ice. And now, God forbid, they're paralyzed or they have a traumatic brain injury.
100%.
And what does it cost to put a sign out that says "Caution, falling ice"?
Yeah.
And now you are okay.
Yeah.
I'm looking around.
And we have a fair amount of clients that say I wasn't really, planning on bringing a lawsuit. I wasn't going to bring a lawsuit, but I did want to because they still haven't fixed this issue or they still haven't put a sign up. I was talking to a client today. She suffered a really bad fall in a parking lot. It's covered in potholes. And she says, I go by that restaurant all the time. They still haven't fixed this. They still haven't done these things. And I want to illustrate to them that, this badly injures people just to the point for them to fix this stuff, just to the point that this doesn't happen to anybody else, which I think is a pretty admirable stance to take on it. And she said if they had, I was injured, but if they had fixed it promptly, I probably would have let it go.
Yeah.
But they didn't, and now I'm going to have to get to that point. But I was in a United airline club lounge. To your point about like warnings and things like that, they are using this like robot to help clean and to take like dishes and stuff like that. And it's got this consistent ringing as it moves around. And I thought to myself, some PI lawyer probably made it so that it has this constant ringing so that people don't back their chairs into it or do something to injure themselves. But we are responsible for all these little safety
that's kind of a lot.
modifications.
People don't see that. And I also think that it kind of goes to, there's this perspective out there, and it's one of the things I hate the most is that, oh, well, your clients are just greedy. This is all just like a scam. It's like a defense lawyer that has drank the Kool-Aid to the whole. They drank the whole gallon.
Yeah.
And you don't have a real case. Your client's just a scam artist or whatever.
Right.
Well, what is the stat? It's like 60% of people don't even bring a case that they could have brought. So you're
Only
going to blame the
40%
40% that actually did.
Mhm.
It's despicable to me, and it's like the McDonald's case that everyone always talks about.
Right.
We need tort reform, which is another conversation
It's a
about
whole another 2 hours.
how
we could
stupid
take.
that is.
Yeah.
So dumb. But this old lady she just drops hot coffee on her lap, and now she gets whatever $2 million.
Mhm.
That's ridiculous. We need to change that. That shouldn't be allowed. Well, why was that even in the public consciousness? Well, one, when they settled that case, she had a confidentiality agreement. McDonald's did not. So, of course, what did they put out in the press?
Right.
Stuff that was favorable to McDonald's.
Right.
What people don't know is that she got third-degree burns, that coffee was like
Astronomically
it was
hot.
over like 160 or 170 degrees Fahrenheit.
Yeah.
And they knew about it consistently, and they actually had in their manual to set it that high on purpose.
Yeah.
I mean, it's egregious. That's
Oh, yeah.
why she got the money. It's whenever you hear an eye-popping number or you see it, it's like, oh, some one person got 50 million. There's no way they could have been hurt that bad. There were 12 people in that jury box that said why, and especially if it didn't even go to the jury and the company paid it. They paid it because they thought 12 people would award more.
Right.
So
Right.
why would they think that? Because something egregiously wrong happened. It's not because of the greedy plaintiffs bar
Right.
that somehow manipulated the laws.
Yeah.
We're not that powerful, I promise.
No,
I wish we were,
Yeah,
but we're
that'd be
not.
great. What have you been called an ambulance chaser before? And what do you think when that happens?
I've
to you?
had somebody say that, oh, you profit off of people's injuries. You profit off of their suffering.
Oh wow.
And I
Okay.
was like, I guess that's true if you want to put it that way, but that's like saying an oncologist profits off of cancer.
Right.
It's like, well, do you want oncologists?
Yeah.
Like, do you want someone that can help you if you get cancer, that can help you treat it and maybe make it
Right.
go away?
Right.
That's the same as what I do. And the person who said it, he's like, well, I didn't mean any offense. I was like, well, you phrased it in
Yeah,
a way
that was
that
a
kind of
pretty
made me
terrible
seem
thing
like
to
you were
say.
making it that
Yeah.
way.
Yeah.
But, I have people say ambulance chaser, whatever, It's going to be a different story when you get rear-ended by a truck.
Yeah.
You're going to call an ambulance chaser right away. And if you
Right.
don't, like, what are you doing? I mean, you're
Right.
just going to, oh, I got hit by a Walmart truck or I got hit by FedEx. They can keep their money. I don't want it.
Yeah.
Who says that? I mean,
Right.
you'd have to be the
No,
biggest idiot in the
no
world.
one is. No one is. Do you think that term, like ambulance chaser, and like this idea about the hot coffee case and nuclear verdicts, and that, do you think that that's kind of perpetuated by this undercurrent of insurance lobbying or insurance marketing?
Well, I don't know I don't think it's natural. I think it's definitely the effect of lobbying, of advertising. If I was them, I would be doing the same thing. If I owned if I was the owner of Allstate, I would definitely be trying to funnel money to impact laws or impact the public so that they would vote for those laws because it makes me more money. And
Right.
that's what their job is as the president of Allstate or whatever. But thankfully I'm not.
Yeah.
But yeah, I don't think it's natural at all because I think when you truly explain things to people, you get the nuclear verdicts on those cases. That's why 12 random people that are not, they get to see the actual facts. They decide cases that way.
Right. Right.
So yeah, I don't think it's natural at all.
Yeah. I was going to ask too, how do you like going to court?
I love going to court.
What do you love about it?
I loved being able to see other lawyers, especially when I was freshly licensed, and I'm not pretending like I'm really experienced at all yet either. I'm not coming up on 2 years of my license. But when you have no clue at all what to do, going to court is invaluable, especially when you're the last case on the call. You could get there and you'd be like, oh, I'm number 30. I'm going to be here for 45 minutes. That sucks. No, it doesn't.
Yeah.
Sit there, put away your phone, and just watch. How does the judge interact with the lawyers? How do the lawyers interact with the judge? How do the lawyers interact with each other?
Yeah.
When a lawyer hasn't done something, which is very frequent when we're behind, what excuses does the judge accept? What excuses do they not accept? What do they get mad at? What do they yell at? I mean, all that is so invaluable. So that way, when it's you who hasn't answered discovery, you can explain, well, judge, X, Y, and Z happened, and you know that they're going to take that excuse.
Right.
It's super invaluable. And it also shows you can see the kind of the players sometimes, because a lot of times you see the same thing. I see Tony Alman at court all the time.
Yeah.
It's help, and you build those relationships, and that helps again later on when you're referring a case or you're getting a referral or you have an opposing counsel.
Yeah.
It's a pleasure to me. You assigned one case to me. I don't know if you're going to remember this. This was a case where a sliding glass door fell off the rail and broke the client's toe.
Yeah.
Every time we had the plaintiff's dep, we had the one defendant dep. Those are my only experiences with that defense attorney. Every time I see him in the Daily Center, we wave hi to each other. I mean, we had one case, and it was a relatively small case.
Right.
But that relationship, if I get a case with him again, it's going to be invaluable. Hey, how you doing, John? Good to see you again. Like, I know he's going to remember the case that we worked on.
Oh yeah,
and
absolutely.
It's nice to have that where you walk into court. I'm always looking. Do I know anybody here? It doesn't matter if they're a plaintiff or a defense lawyer. If we can get along, I'm like, hey man, how you doing? Give him a fist bump, give him a handshake. See you on the next one. It's
part of the whole.
Mike always says he's like the 22nd on the floor of the Daily Center is sometimes like social hour for the attorneys. And it kind of is.
Absolutely.
But it's a good thing. You should have those relationships. You shouldn't just be in our little tower here.
Right.
Just sitting at your desk. I mean, you got to get out of your desk, out of the office sometimes. And court is a great place to obviously meet other people.
Is that something you're grateful for because with COVID, we were all Zoom. And then they forced us back, in person.
I like the in-person. I don't know if you saw this. There was a LinkedIn post a while ago, but it was somebody posted that like a federal judge ordered that the attorneys for both sides go out to lunch.
Oh, that's
and
fun.
They went out to lunch and of course ended up discussing the case. And I think they ended up settling it. And it's like, all it took was a lunch. All it took was you to talk with each other.
Yeah.
And not over email, not over the phone. No, you're sitting there across from each other, like kind of like we're doing now. It's hard to be a big jerk if you're sitting across from somebody. It's just going to change the dynamic a little bit.
Yeah.
And I think that is what in-person court does a lot of times too. And the judges have said that. we want to get the attorneys talking because there's a lot when you're sitting on a Zoom call. It's the same thing because I went to the Zoom school of law.
Right.
You don't get to chat with your buddy sitting next to you. Hey man, I'm going on vacation next week. Can I get your numbers so I can get the notes?
Right.
And now you got a buddy to text. Hey, what did you get on the test? I missed X, Y, or Z. Did you get that? Oh, can you explain it to me?
Yeah.
You missed all that because on Zoom you just join and you can't like whisper. Yeah, you could type to somebody, but that's weird and awkward.
Weird. Yeah.
So you don't do that, and then so you just log in. Like I would literally roll out of bed, log in, camera off, listen, lecture over. Close laptop, done.
Yeah.
And that's an efficient way to go through law school.
Right.
But it's not a very fun way.
Yeah.
And it's the same thing with court.
Mm-hmm.
You know, I can't talk to anybody. I can't say hi to anybody. And it's just up and down. And it's just like, I much prefer in-person court than over Zoom.
Well, and you're right. And I think the benefit too is the potential settlement discussions is that you get them live in front of you and you say, hey, can you get authority with an adjuster? Or, can we discuss like getting something scheduled as opposed to emailing and seeing if they'll email back or call back or whatever. So I think that's a fair point too.
Think about how many emails we get a day, how hard it is to respond. I mean, you literally can't respond to all of them.
Right.
But if you're in there in person, it'd be very awkward if I asked you a question and you're just like,
right, not saying
and
anything.
you walked out the door. It'd be like, that was the strangest thing I've ever seen.
That
never happens. It doesn't happen.
Yeah,
so
for sure.
Yeah. So what's your morning routine like, Jess? I know you're an early riser because you usually get to the office before me.
Yes.
And I see you online sometimes real early.
Yes. Yeah. I wake up at 6.
Oh, wow.
And I've got like my very demanding pugs, so I have to feed them right away, get them situated. And then I try to get here by like 7-ish for the most part. Because I enjoy the like quiet time in the office because there's not really a ton of emails that are coming through. I'm not really getting a lot of client calls. I always send myself an email that night with like kind of pressing tasks. So the first thing I try to do is read the email that I wrote to myself of what I'm going to do through the day. Mm-hmm. I try to plan out what I'm going to do in the day, but
how well does that work?
Yeah, not great. There's other plans, but depending on what I'm going to do, like I'll either prep for my deposition. I had mediation today. I'll prep for that. And then just kind of see where the day carries me for the most part. So I would say like my 6 to 9 is pretty consistent. Like I eat the same breakfast every single day.
What do you eat?
I have my 2 hard-boiled eggs and I have a smoothie. So I got my protein and my
I think that consistency is key because I am always all over the place. But what about at night? When are you sitting down to write that email? Is it like before you leave for the day? Is it?
No, it's usually like 9 o'clock at night.
Okay.
I'm writing that. So my time leaving is pretty variable. I'll try to leave a little early to see if I can avoid traffic, but most of the time I'm leaving like 6 or 7.
Yeah.
And then I'm having dinner, like winding down. Try to hit 7,500 steps a day. So I'll like go on the treadmill for an hour or so, depending on how high or low I am. And then I work out with a trainer 3 days a week. So depending on if that's happening. I do think like personal health and having some part of a routine is good for you. Especially, I know lawyers don't have the best work-life balance. So I do try to prioritize, like, I, see a therapist once a week. I, work out at the gym. I make sure that I have, dedicated, like, time with friends and family, things of that nature. And then I'm usually trying to get to bed before midnight, hopefully.
Yeah.
But I'll have like a wind down of, watching a television show or something kind of along those lines. But I do value like the consistency of, what I'm eating, every day and generally, what I'm doing as far as after hours, because I don't want to spend a lot of mental energy on those types of things.
That's exactly what I was going to say. That's why Steve Jobs wore that black turtleneck all the time. Well, I don't have to think about what I'm going to wear. I want to use my decision-making power on something that's important rather than what am I going to wear.
Yeah. The other thing that I did that I have started doing, which is really nice, is I do have a housekeeper that does my laundry and cleans my house.
Nice.
Because I was looking at how I value my time. And if I value my time at, $100 an hour, I wouldn't pay someone $100 an hour to do all that stuff. So I'm not going to do it.
Right.
So I have someone come in and do that. And I feel very privileged that I'm in a position that I can do that. But it's also just made my life a lot less stressful. So I'm a big fan of that.
Certainly.
What about you? What's your routine? morning and night?
I'm learning that I think I need to develop one because I'm kind of all over the place. There are nights where I'll pass out at 9:30 because I was so tired from the night before, and there's some nights you'll know I'll email you at 12:45 at night, and I'm up until I did one to Max a couple weeks ago where I emailed him I think at 12:55 or 12:53. And I got an email back like 5 minutes later, like 12:58, and it was just go to bed. And I responded back, well, if I go to bed, how am I going to settle as many cases as you, Max?
Right.
Because he's leading the leaderboards over here. But yeah, I try to stay relatively consistent with, when do I kind of like start when I wake up. I also have the benefit of having my pets. So my cat is always at my ear right around 6 o'clock. I make the error though of I get up, feed him so he stops meowing in my ear, and then I go back and I lay down.
Oh yeah.
But I probably should wake up a little bit earlier. But yeah, I think I need to develop a lot more of those routines because I don't go to the gym. I don't see a therapist. I don't eat the same thing every morning. Most of the time, I actually find myself more productive and better when I don't eat at all.
Oh,
For
really?
the first, not like ever, obviously.
Right, but like
I'm still alive.
Before like noon, essentially?
Before noon, but honestly, a lot of times I feel pretty good if I can stave it off until 4 or 5.
Wow.
I get a lot more done. I feel like the moment I eat, it sounds so dumb to say, but like once my actual hunger is quenched, almost my hunger for the day is quenched.
That's
it's like, it's weird. I don't know. Yeah.
I mean, everybody's different. I think that like the 3 meals a day doesn't work for everybody.
No, it certainly doesn't work for me.
Yeah, I think that some people, I have friends that'll fast until like 12 or 1. And that's pretty effective for them. Like they'll eat between 12 and 5 p.m. and then just be done.
Yeah, that's really, really what I try to do. I usually push it because I'm always a late night snacker. So that's why I try to keep it into that window. But it's like, okay, if I start eating at 5, then I can have until 10. But if I did the 12 to 5, I knew I wouldn't be able to follow that. But relatively, when I do wake up again, it's around the same time. It's a little bit later. It's like 7:15, 7:20. Shower, get my suit on, check to see if I have any emails. Usually I don't, that early in the morning, but sometimes there's usually like a Teams message going on or Michael send the ITLA thing and I'll look at, okay, is there anything from ITLA that I want to look at? First thing I do when I usually get in the office is check all those like ITLA emails. And because if there's nothing that I see that's important, I just like toss them. But if there's something that's important, I just keep it in my inbox so that way I can follow up with it later. So if there's a question about, oh, hey, or there's just like, like I have a motion to bar this expert, or I have anybody run into this issue before, or here's a really good set of interrogatories for this. I might not have the time to save it in a place that I want it, but at least if I keep it in my email, the theory is that later on, sometime I will be able to be like, oh yeah, I remember that. I have a that saved somewhere. Yeah. And I'll be able to go find that. But that's usually what I check the first thing when I get in the morning. What I'll also do, and this is a habit that I started as a clerk and I never have really fallen away from, is I check the calendar for the whole office, and I see what everyone else has got going that day.
That's really smart.
It's just, I'm curious.
Right.
And then if Roy or you or anybody has a mediation going, I click on the case. Is it a big case? Like, I'm just curious, naturally. And then I want to say, like, hey, did your case settle? How much? Like, it's interesting to me. So
there's been a few times I've been like, how did you know that? But that's great. That's really smart.
Well, as a clerk, I wanted to ask, well, one, can I do anything to help? Yeah. Can I sit in on it so I can learn? Now it's more of just my own curiosity of like, okay, well, how well are they going to do on that case? Is it going to get settled? It helps me with my own, I can learn a little bit from, well, who was the defense attorney? Who was the carrier? What type of case was it? What did it kind of settle for?
I would say, I think you are already doing this already, but, take chances. And even if they're, don't have a total fear of failure. And I say that in the context because I think everybody has a fear of failure.
I can definitely say that I was petrified at first of making a mistake. I feel like it's getting a little bit less. Yeah. Every little bit of more success I get a little bit more confident. Yeah. But part of getting greater gains is by taking a little bit greater risks. Not like bad risks. Right. But, calculated risks.
Yeah. Yeah. I think that a lot of attorneys and especially like trial lawyer attorneys have fear of failure. And no one obviously wants to have a not guilty verdict. We had one this week and it was, really unfortunate. But we have to recognize that there was clear benefit to doing this. We didn't really have a choice. And we can't approach things from a standpoint of letting that fear drive our decision making. Because at the end of the day, we do have gut instincts. They do have, value and merit, and we have to trust those things. And I have been, when I have looked over my fear of failure. When I've like powered through it, I've always been grateful for it, no matter of the outcome. And so I say this from the standpoint that, I haven't seen you be fearful, but I just want to continue to reinforce that to you.
I appreciate that advice. It certainly is. It goes back to kind of like when we talk about negotiating. The worst I can say is no.
Yeah.
And you're not going to get what you don't ask for. So
Right.
when I was telling you about that salon case where a client who has their eyebrows burned and they deny liability, it's a really small case. And it's like, okay, I could have just withdrew right then. And I got advice from another attorney in our office who basically said, yeah, you should just withdraw. I mean, there's nothing there. And I even had typed up an email to the adjuster basically begging for a nuisance offer. And I was just like, oh, man, maybe I should just withdraw. Like, what am I doing? But then I was like, no, why? Like, I'm already here. I've already sunk the time. Let me just get her on the phone instead. The email is dry. I can be persuasive. I like to think that I can be charismatic.
Right.
And I call her up, and then like I told you, next thing I know, today I get a $5,000 offer. Now, is that earth-shattering? No. But it's a successful outcome. A withdrawal is a failure. We didn't get a recovery.
Right.
That, by definition, that's a failure.
Yes.
On this, I can get a recovery now, and I know the client's going to be okay with it. So that's actually it sounds what I'm going to say, but it means the same to me as a $100,000 case or a $500,000 case. I got to win. When it was actually, I snatched victory from the jaws of defeat. Right. And that actually means more to me than, you get rear-ended by a truck. Mike always says, if a lawyer, any idiot lawyer can settle a case where a kid gets killed in a crosswalk by a PepsiCo truck.
Right.
It's easy.
Right.
Liability's not contested. The kid is dead. They're going to pay. It's what about those cases where it's like, it's a small case. A lot of lawyers are not even going to waste their time on it. And especially when you got to fight through, I got 2 denials on that.
Right.
So now we're reevaluating and we're at 5. And I was like, okay, well, I'll just take it. And then my next thought was, well, I demanded 12. Why don't I go down to 10? Maybe I can get them to come to 7.5.
Absolutely.
And it's just like, why not?
Right. No, 100%. And I think that there are many other lawyers that would have been dictated by their fear of failure, fear of rejection. I think go hand in hand because failure is the ugly cousin of rejection. And because of, I think, your background with going door to door, you're not as fearful of rejection. And so a lot of people, I think, are dictated by that, and they're allowing that to control their decision making. And I think you can also hear it with lawyers as far as, we'll have clients that came to us after 9 lawyers rejected them, and they have a compensable case. And if that client had accepted what that lawyer said, they wouldn't have come to our office.
Right.
So they're powering through their, fear of failure, fear of rejection, and at least trying. They're coming to us. We're getting them, a good result. So I think that's the biggest battle that we will continually have in our lives is this fear of failure. Because jury trials are incredibly scary. And it is something that a lot of people can fear because it's the unknown. And when you do have somebody whose, life and injuries, it somewhat feels like it's in your hands, it can be scary to walk away from a big offer. It can be scary to, to say that we're going to power through for the jury trial.
Yeah, well, it goes to one more quick point, and then we'll answer the last question. But Rudy had talked about to me, he's like, his case that he settled last year for 1.3 or 1.4, and at mediation, they offered 1. That was their top. They said, we're not offering you anymore, take it or leave it. And he left it.
Yeah.
And he said, I'd actually never even been offered $1 million before. And so to walk away from that, to say, no, we're good.
Yeah.
And then 3 weeks later, they offer 1.3 or 1.4, which they said they would never do.
Right.
And then now they did. I mean, he could have taken the $1 million at the mediation. The client was on board. Mike was there, I think. And he said Mike was on board. He's like, I was the one that said, no, it's not enough. The case is it's actually worth more than that.
Right.
And they're going to pay that. Trust me. And they did. And had they not, he probably could have taken him to trial and gotten double. He's a good lawyer, so I'm sure he would have. But, I mean, those types of stories and examples are so critical to showing why we should do that. I mean, I would be terrified to walk away from $1 million. The thought in the back of your head, okay, what if we go to trial? What if we get blanked? What if we lose? What if we get 100,000? All the cascading thoughts of negative outcomes.
Yeah.
But what if it went right?
Right.
That's all you got to think about.
Yeah. Well, and that's the thing. Rudy trusted himself and his gut, and he was right.
Yeah.
And he was correct. And I think that, when you have that blind faith, I think that's almost more terrifying to these insurance companies, is that they left $1 million on the table, and I'm sure those insurance companies went, holy crap.
Yeah, what type of lawyer are we dealing with here?
Right.
We offered him $1 million and he walked away. He must know something that we don't. Like, it's either he's wildly off base and he doesn't know what he's doing, or he's a madman and he's actually going to hit us.
Yeah.
And what does he want? Like, what can we
Right.
get him to stop
Yeah.
going after us?
Yeah.
And the answer was 1.3 million.
Right. That was what did it. And I think that with, jury trials as well, juries can sense that fear of failure too. And I think that has an effect. And I think that the confident lawyers, because remember you were telling me about that MedMal trial that you watched with the defense lawyers closing, and it was so organized and succinct in the way that he was
So good.
Yeah. And I don't think he had that fear of failure in a sense. I think he had this confidence with it, and that translated to the jury, unfortunately, for plaintiff's lawyer. But
I think that just one small point on that, it's easier for defense lawyers to not have that fear of failure.
Yes, that's true.
Because it's not personal for them. They get the same paycheck no matter what.
Absolutely.
Whereas for us, we are contingency fee based.
Mhm.
So if I get $1 million, I'm making more money.
Right.
If I get zero, I make nothing.
Yeah.
So of course I'm going to be a little bit afraid of making zero, because that means I just lost all that money.
Yeah, and you're looking at an actual person in the eye versus a defense lawyer that's looking at a hospital representative or or an insurance company. But the first case jury trial that I ever had, it was a contested liability left turn case, and I was terrified, and I was half tempted to take this lousy offer, and the client was on board, and I thought to myself, you know what, let's power through, and it was successful, and now I can say that I had that.
Yeah.
But it was just powering through this idea of failure or rejection, and accepting in myself that the outcome was going to be whatever it was, but that I would be proud of myself no matter what.
Fantastic. Building off of powering through and being proud of yourself, Kyle, you dethroned Jess in February as the leading settlement closer.
He did. I cried myself to sleep the other night.
It'll be big news when I dethrone him, if I ever do, over the whole year.
He's on my coattails.
We'll see.
I was going to say.
Well, after you had your mediation today, you're going to be almost $1 million ahead of me, I think. I keep close eye on the numbers. What was the question again? How did I feel?
No question. How do you feel?
How do I feel? I felt good. I will say I got to put it into context. The reason that I dethroned Jess and was the leader in February was I settled a case that Jess gave me for $900,000, so that doesn't hurt. But I did have to do some work on the case. I had to kind of go back to what you said earlier, like how you said you maybe were a little bit more bullied in high school. I love being able to. You can clarify it as standing up to the insurance companies.
Mhm.
I like to describe it as I bully them.
Yeah.
Because they bully our clients all the time.
Absolutely.
And they bully people that aren't our clients, because they actually don't bully our clients because we stand in the way.
Right.
But when they try to settle with people, or we've had cases before where a client will come to us and they're really injured, and they've already signed a release.
Yep.
Because some snake farm adjuster got them to sign it away for $5,000.
Yep.
And their case was worth 10 times that or 20 times that. They bullied that person.
Yeah.
And it gives me great joy. Almost nothing else gives me greater joy for them to bully them back.
Right.
Because they deserve it. And I like that. So I bullied the attorney on that case to cough up the policy limits. So that felt great. Felt like winning the lottery, to be honest. Because it was so, before they settled for $890, the offer was $100. And it was $100 and it was like $200 unofficially. And they said, we won't make another offer until you come below $500. I was like, are we talking about the same case? Our client had $700,000 in medical bills.
Yeah.
The $890 that was left was the remainder of the policy limits because there was somebody else that was injured. And so that was all that we could get.
Right.
And that's what I wanted. And that's what the case deserved. And that's what I got. And that was truly helpful. But it felt great. Like I've said before earlier, every little bit of success, it's like a positive feedback loop, because now I know how to settle a case for, I settled an amusement park case for over $1 million.
Yeah.
Slightly over. It was only $1,005,000, not 1.5.
It's over $1 million.
I wish. But yes, it was 7 figures. And that helps. When I think back to my first case, I was settling a nail salon case. I think it settled for $12,000 or something. I mean, I think I sent 12 emails back and forth between me and the adjuster. Yeah. I mean, it was just like, I just don't know how to do this. I don't know how to do anything. And then now it's like, okay, well, I've done that. And now, all right, now I've settled the case for, 7 figures. I know how to do that. It's just, it builds. And to lead 1 month, maybe I'll lead again. Maybe I can get to leading for the whole year. It's a good feeling, especially because we got some good attorneys here. It's not like the competition is weak. It's pretty strong. So to get on top 1/12 of the year, I'll take it.
Yeah. And I was extremely thrilled to see that. And I had every expectation that it was going to happen. And I think that the nice thing about our environment is that we do celebrate one another. And I do love your success because in some sense I do feel that it's reflective of not just myself, but everybody in the office, and that we've created this really excellent dynamic and culture in that we are willing to help each other because it collectively benefits us all.
Right.
And, so if they, like, for example, I have a case with that same attorney the end of this month at mediation, and I can say, hey, my associate got 890 out of you. And it benefits us all. But it also, I think, shows that we are phenomenal at cultivating phenomenal talent. I keep saying the word phenomenal, but that we find the right people. We are looking for people that are impassioned over what we do. And we are able to, I would say, grow the next generation of people that if something were to happen to me tomorrow, I would feel great about the people that are here at the firm and that they would continue and carry on the legacy that we're trying to